Law&Crime Network, everybody. This is Jesse Weber, and you are watching testimony in the Jason Riley King case out of San Diego, California. This case of that former Marine who was accused of driving drunk on the wrong side of the road, resulting in a head-on collision, killing 2 people and injuring 3 others. The other case that we are covering is the William Woodward case out of Florida about a double murder. Now, the reason I'm talking about both of these cases is because we have a very special guest with us to try to understand what is the jury thinking and what kind of jury should have been selected or will be selected in these cases. I want to start off with the Jason Riley King case. And to help me talk about this is jury consultant Alan Tuerkheimer. Alan, great to have you here on the program.
Great to be here. Good to see you, Jesse.
And for our viewers, just to let everybody know, we were talking in the break, is that your father was my teacher in law school. So it's a small legal world.
Right, exactly. It all comes together, right? Everything related.
Everything's related. So let's start off with the Jason Riley King case. And I'm so happy you're here because I asked this first question to other guests, but now we have an expert in this field to talk about. In this King case, if you are the prosecution, what is the ideal juror for you that you want to select on this panel, on this jury?
Right. So I would want a pro-authoritarian type who really doesn't have any room for error when it comes to rules and rule following. Somebody who's very strict about consequences and somebody who thinks that people get their just desserts. And this is the type of juror that'll look at what happened. And since there's no question by either side about how these 2 med students were killed and how the accident unfolded, it's really just about what charges are going to the jury's going to embrace. The type of person the prosecution would want is somebody who is really going to stick to the idea that, hey, that he was warned, he took this class 8 days before it happened, even though he didn't set out and purposely devise a plan to kill these med students, he should have known what he was doing. He had many chances to abort his night as it unfolded, and he didn't. So that's it. He has to be punished to the fullest extent of the law, and I'm going to vote second-degree murder. It should be what we should convict him of. And there are jurors who think that way versus a juror who might think some people deserve second chances, some people just make a quick mistake and it shouldn't affect them for the rest of their life. And there's a little bit of wiggle room in some of these notions that, yes, people should get what they deserve, but let's cut this guy maybe a break. He's young. He made a mistake. A lot of people make this mistake. They just don't end up hitting a car full of 5 med students and killing 2 of them. So interesting dynamic, and certainly different types of jurors that each side would be looking for when selecting a jury in this case.
Now, how does it work in terms of asking either side, whether you're the prosecution or the defense, how does it work about asking these jurors experience or their thoughts on drunk driving in general? How are those questions tailored for those jurors?
Right. So some of it would just be based on what somebody's job is. If somebody's, to take an extreme example, law enforcement, they're usually by the book, authoritarian, they have deference to authority. And if somebody maybe is more in a social science setting where it's more people-oriented, where it's more about some kind of rehabilitation, then you can make some inferences based on that. But it's also the way that prospective jurors talk about rules, prospective jurors talk about drunk driving, like you pointed out. And then you can kind of get a sense of whether or not somebody's going to be a little bit lenient, which is all it might take in a case like this, or is somebody going to be very airtight in their conception of what the law is, what happened here, and what course of action they're going to follow through on when it comes time to deliberate and render a verdict.
We had a guest on yesterday, I think it was Jessica Ramirez who brought it up, who said that there is a culture and how certain people in certain cultures or certain backgrounds, how the idea of driving drunk is not that big a deal. You know, they feel, hey, I had a couple of drinks, you know what, don't tell me I can't go behind the wheel of my own car, I should be allowed to. How does that play into looking at certain jurors, their backgrounds, their thoughts on it, maybe even particularly for the defense, trying to find some jurors who will say, you know what, I don't, it's not the worst thing a person can do, but obviously if it results in the death of somebody, that might be a different question. But I'm curious how that works as well.
Right, and the key thing is who's going to be able to evaluate this whole case without looking at the end result. Obviously, they know what the end result is, but how much is hindsight going to come into play? Some jurors are going to be able to get inside Jason Riley King's head before all this happened, and are going to say, okay, this is what he was doing at this stage. He was at the hotel or the motel, he was drinking, then he went to the bar. While others are going to have, it's going to be impossible for them to even tease out the basic thought process before the accident. So the ones who are going to evaluate his state of mind with the end result, the two fatalities, it's going to be hard for the defense to win them over. So what you have is, and this is an interesting case because most jurors probably have been in not the same exact situation, a similar situation. Like you pointed out, he was drinking and he got into a vehicle. Well, sadly, a lot of people have that experience, and there could be something in someone's background or culture, like the guest said when they were on, and some jurors are going to say, well, you know what, I remember I was younger, or it could be a couple weeks ago or last year, I allowed to drink, but I had to get home and I did this. And you're going to have others who are going to say, well, I had some to drink, but I stopped and I let somebody drive me home. Those jurors might have been stricken during voir dire. Peremptories were probably used because the defense isn't going to want somebody who's going to say, hey, I did the right thing and I didn't get behind the vehicle. I actually listened to people. So that's the conversation that I think the attorneys had before picking a jury, and those are the types of questions and types of perspectives that they were going to ponder when selecting a jury, because just about everybody has probably consumed some alcohol, and like I said, just about a good percentage of those people have probably been in a car after driving, and then it goes down the process. Which ones didn't drive? Which ones had way too much? Which ones lucky? Which ones had close calls? And that depends. And those experiences are going to determine how they see the evidence unfold in this case.
You mentioned something I want to pick a point on when you said that the prosecution would seek jurors who are authoritarian, maybe even people in law enforcement. This might be a simplistic way of thinking about it, but is there any bias on the terms of finding jurors who might be authoritarian, might be involved in law enforcement in some way, and you see this Marine, and this Marine, in a similar kind of way, is there any bias towards that you have to fight over? Here, this guy's a Marine, you might feel a little sorry for him, you both are in kind of protecting the public. Is there any kind of danger there?
Yeah, I think you're right. It's a double-edged bias. I tend to think somebody who's more pro-authority and pro-law enforcement, I think they're going to probably put some distance between themselves and this Marine. So maybe in their minds they'll think, well, yes, I respect authority and I defer to authoritarian principles. He didn't. He didn't do that. He took his course. He didn't take it seriously. He wasn't a serious Marine. I still think an authoritarian juror would be more favorable for the prosecution, but there are some people who, no matter what, they will align with somebody in the military. And so it could be a former vet. It could be a vet. It could be somebody who thought about maybe going into the military. For whatever reason, they just might hold military members in higher regard. So that's also something that should have been fleshed out either in a questionnaire or during the jury selection process when they were interviewing prospective jurors, because there are some people, even if they're pro-authority, doesn't necessarily mean they're going to align with the prosecution. When you have a defendant here, military member, and was on the night of the accident.
We keep talking about the defendant, but we should talk about the victims. And the reason I want to talk about the victims is when we've been analyzing it here on the network, one of the things that's been interesting to note is when we have this battle between whether it was murder or whether it was manslaughter and how will the jury ultimately vote, one of the things that people keep saying is, isn't there a danger that when you look at these young victims, I mean, we have Ann Lee Baldock, who was 24, and Madison Elizabeth Cornwell, who was 23, these two young UCSD medical students, these two young, beautiful girls, how much of that is a bias in terms of the jury, and how does the defense fight against that? I mean, these victims were completely innocent in this collision, so how do you fight against where jurors will use their sentiments above the law?
Right, it's such an uphill climb, and I assume that this took place during the jury selection process, or at least some of it, where the defense got up and tried to gauge by just flat out asking who here is going to have a tough time being fair to my client and holding the prosecution to their burden when you have two young women who were med students, completely innocent. They did nothing wrong. They weren't doing anything improper on the night in question. Who here is not going to be able to get past that? And so maybe a few jurors raise their hands. The judge let a few of those jurors go for cause. If they didn't, then maybe the defense struck them using a peremptory challenge. But once the jury's seated, yes, absolutely. This is an emotion-based case. Every time they hear about the victims, it's sad. Now, as trial goes on, certainly the jury knows that. They're not going to want states that play at their heartstrings. I don't think the state is, but meaning they can overplay that hand. So the jury knows that it has for times during the case where it's emotional, and it's really hard for the defense to overcome that, but the prosecution doesn't want to overdo it. What I've seen and what the research says is that an impulse to punish and to really drive, in a civil case, a high damage verdict, a punitive damage verdict, or a murder charge here versus something lesser, it's really anger as opposed to sadness or emotion. So while the victims here are going to have an influence on how the jurors assess the case and how they deliberate, there has to be something there that fires up the jury, that gives them an impulse to want to punish, that gets them mad as opposed to just being purely saddened for the families. So if that's something that the prosecution should be thinking about, it looks like they have, with some of the things that they've done so far to get the jury angry, because it's really anger that's going to fuel a more likely second-degree murder scenario versus a reckless manslaughter.
Alan, I'm happy we have you on because this is a question I think a lot of people have, and it's a question that I'm not sure everyone can answer, so I'm happy we have you on to answer this one. You talk about the jury questions and how juries are selected during the voir dire process. What's the likelihood that when a juror gets a whiff of what this case is about, they're not saying they know the characters, but they get an understanding of what's at stake here, that they might not necessarily be entirely truthful about their feelings during that selection process, and as you said, who here may be unbiased, but when they know that there's two people who were killed, they may lie or they may not be entirely truthful, and they may come on the jury anyway. I'm not saying at all that that's what happened here or anything, but I am curious from a general perspective, what is the danger of a juror not being completely honest during a jury selection process in order to hopefully get on a jury?
Right. That's something that the sides have to watch out for once they start hearing about the basic facts of the case, that somebody is it's a stealth juror or somebody who has an agenda. And that's something that it does happen. And it certainly happens it's more common in a higher profile case. So in a case like this, yes, there might be some people on the panel that think, I want to get on this jury for whatever reason. You never know. Maybe it's strongly one way or another, but it might just be because they want to have their 15 minutes of fame, whatever it is. So
yeah,
I think it really takes a certain personality to get there and be deceptive in court. Now, you might have somebody who thinks they want to do that, but once you show up in court as a juror, it's very intimidating. It's a new scenario. There are all these strangers there. There's a judge there. You're getting asked pointed questions. The severity of the case. It's a very emotional case. It's difficult for people that might have a tendency to want to get on the jury to bend the truth, to agitate a lie. That said, the Constitution do that, and it is something that happens from time to time, and it's really hard to identify that individual, and that's what each side has to do, and each side can do that. Sometimes they do it with a jury consultant like me, or sometimes they have somebody watching the jury closely, watching out during the question. Just does.
Yeah, Alan, stand by. What we're going to do is I want to talk more about this case, but I want to play for everybody, our viewers, an additional clip now from the Jason King case. And when we come back, Alan and I are going to talk a little bit more about King, but we're going to focus also on the William Woodward case out of Florida and why a jury has yet to be selected in that case. What I want to play for you right now is the continuing testimony of Officer Brad Clinkscales. And now he is showing pictures of automobiles that were involved in the crash. After this short clip, Alan and I will be again talking about the juries in both of the cases we're covering here on the Law and Crime Network. Take a look.
Now, in the course of your investigation, investigation, after figuring out that the defendant had been in cahoots in a time frame, did you try to go back and figure out or check with businesses anywhere in the area to obtain any surveillance video that would show portions of the 163?
I did.
Why did you do that?
I wanted to know where King got on the freeway the wrong way.
Were you able to figure that out?
Not definitively.
Were you able to look at any surveillance video from any businesses that are along the 163?
I checked with a few different businesses that were in the area.
And when you say in the area, where are you talking about?
Along the east side of the 163 between Friars Road and I believe it was Genesee Avenue East.
Officer Clinkscales, on the screen we have a exhibit number 4, which is an overhead screenshot of a Google map, and you're talking about the 163, is that right? And Genesee, which runs to the left-hand side down through the 163?
Correct.
Okay. On this Google map, it has a word Judson Street condos, and then we get, if we keep going farther south on the 163, we hit the words Fashion Walk condos, then Fashion Valley, and then we come to the 8 intersection. Am I reading those 3 correctly?
Yes, you are.
Okay. When you say that you were trying to find businesses in the area that may or may not have had surveillance, did you look in the area of the Judson Street condos?
I did.
Now, if you could point to us, point for us, there should be a pointer there to your left-hand side. Where is the In Cahoots bar from on this map?
So the mission, let's see here. So the off-ramp to get to it is Friars Road, which is right here, next to where it says Fashion Walk Condos. And so that would be, you can go east on Friars Road, and this first road here is Mission Center Drive. So In Cahoots is right where I've got my pointer now.
Let the record reflect that the witness in exhibit number 4, he first was pointing to a roadway, the first roadway after the intersection 8 in purple that is white that goes off to the right-hand side as being Friars Road. He then followed the pointer along to the actual F in Friars Road on the map, and there was a roadway that went south from there that at the top of that roadway was Friars Road, and at the bottom of that roadway it says Westfield Mission Valley. Was that the street that you were referring to?
Yes.
And after checking with the businesses in that area, how many businesses do you think you contacted?
Approximately 3 to 4 businesses that were in that area.
Is there a lot of businesses along between the I-8 at 163, along the 163 past Genesee, that actually face the 163?
There's not very many.
And were you able to obtain any video from any of those companies showing the 163 on the early morning hours of the 16th of May?
I was.
Did any of them show what you were looking for?
They showed over at the NASCO property that is along the 160. It's east of the 163, north of Friars, and south of Genesee. There's like a General Dynamics NASCO building, and I was able to get a little bit of video from there that showed a high profile or a large vehicle with flashers on that was traveling wrong way, but it didn't show me where the vehicle got on. It just showed me that that vehicle was wrong way north of Friars Road.
How far north did you look in trying to obtain or figure out where the defendant got onto the freeway?
I went up to, I believe it was Mesa College Drive. I wasn't able to find anything near Mesa College Drive, and then I backtracked to the ramp that's in between Mesa College Drive and Friars Road, which is Genesee Avenue East. So I don't remember going much north of Mesa College.
And could you determine where the defendant got on the freeway?
Not definitively.
You mentioned that when you were at the scene, you had your partner, Officer McBrady, take photographs of the vehicles. Is that right?
Right.
At some point in time, did you actually visit the impound lot where the vehicles were stored?
I did.
When do you think that occurred in the course of events?
I'm going to estimate it would have been within about 2 to 3 days of the crash.
And when you went to the tow yard, were you able to take a look at the vehicles and the condition they were at the tow yard?
I was.
If I was to show you some photographs of the damaged Prius, you think you'd be able to identify them?
Yes.
Does the court have any objection with me showing the photographs at the same time as laying the foundation? The defense has no objection for these photographs.
That's fine. No problem.
Thank you, Your Honor. Starting first with photograph number 47. Officer Clinkscale says, what's on the screen? Does that match what's in front of you marked as exhibit number 47?
It does.
What are we looking at in exhibit number 47?
This is a picture of the Prius that was involved in the crash, the Prius C.
And is that the photograph that was taken actually at the tow yard?
Yes, this is in the evidence, the secured evidence portion of Star Towing's lot at 8060 Armour Street.
And is this photograph, does it accurately depict what the vehicle looked like once it reached the tow yard?
It does.
What are we looking at in exhibit number 48?
That is the same vehicle from the other side in the same parking lot.
From the profile that we're looking at on this one, would it be fair to say it's from the passenger side?
Yes, we're looking at the passenger side and the front of the vehicle.
And does that match what's in front of you marked as exhibit number 48?
It does.
What are we looking at in exhibit number 49?
That is the rear of the Prius C.
And at the rear of the Prius C, we see that there's something around the very, kind of the back left end, or the back driver's side. What is that?
Are you referring to the thing hanging off the back of the car?
Yes.
That is the left side rear lighting assembly.
And is it fair to say that in this photograph, exhibit number 49, at the tow yard, some of the items from the vehicle were moved or changed from how they looked at the scene? Is that fair?
Yes, that is.
Why is that?
They were put on a tow truck and moved to a different location.
And in the process of moving the vehicles, is it fair to say that with CHP or the tow company had to actually change some of the configuration of the vehicles to get them on the tow truck?
Yes, they would have had to drag them onto the tow truck, and then in addition to that, the tow trucks aren't like a secured airtight box. They are sitting on top of that tow truck as they're being transported, subjected to air.
What are we looking at exhibit number 50?
Okay, this is the same Prius C that we were just looking at, and this is looking down into the driver's seat of the Prius. So that's the steering wheel that's kind of in the middle lower portion of the photograph.
If you could, with the pointer.
Yes.
We're looking here, and on exhibit number 50, let's start with from the right-hand side. What are we looking at in that right-hand side of the photograph?
We're talking about here.
There's a white portion that goes up about halfway, starts about a third of the way up the photograph, that goes all the way to about 2/3 of the way up. There's kind of like a white material or a lighter color on the photograph, and then it kind of bends and shifts and goes to the very top. What is that?
This appears to be like the headliner that would sit above the passenger compartment of the Prius.
Okay. And could you point, please, where the steering wheel is in this photograph?
It is right here.
Would it be fair to say you're pointing right to almost the very middle of the photograph? Is that fair?
Yes.
And could you please point to where the dashboard is in this photograph?
Well, it's broken here, and then it continues up here.
So the first place that you were pointing was kind of just an area to the bottom left-hand corner of the photograph. There's some wires and it looks like parts or mechanical parts or plastic. And then you pointed to the plastic area that runs diagonal, kind of slightly left to right, kind of going from top to bottom in the photograph. Is that where you were pointing?
Yes.
What are we looking at in exhibit number 51?
Exhibit 51 appears to be like loose parts of the Prius that were loosely put back together in kind of an area in that same evidence, or in the tow yard parking lot.
And what are we looking at in exhibit number 52?
52 is going to be similar to a view that we already looked at. You can see in the middle lower portion, you're looking at the top of the Prius from the outside the driver's side looking in. So that's the roof of the Prius peeled back, and then underneath it is the headliner that would normally go above the driver.
And you mentioned that when you were on scene, you also had the opportunity to do a walk around and take a look at the vehicle, and you had Officer McBreedy actually take photographs of it. Is that right?
Right?
May I have just a moment? Sure.
Welcome back to the Law and Crime Network, everybody. This is Jesse Weber. In a day where we are showing you replays in the Jason Riley King case out of San Diego, California. And the reason we are doing that is because the trial is on break right now until Tuesday after the holiday weekend, where it is going to pick back up, and we've been discussing it all today. But that is not the only case that we're covering here on the Law and Crime Network. No, there's another case as well that we don't want you to miss. It's a case out of Titusville, Florida. It's the case of William Woodward, who's accused of shooting and killing two neighbors and injuring a third. And apparently it might have all been captured on surveillance footage. The man who prosecutors say dressed in camouflage and hid in the bushes for this surprise attack is now claiming self-defense. He's claiming justifiable homicide. And in fact, the defense is trying to argue that the community at large has supported his client's actions. And the two individuals who were killed in this attack were 39-year-old Gary Hembry and 44-year-old Roger Pecor. It's also a high-stakes trial, considering that William Woodward faces the death penalty, a potential of the death penalty. So there's a lot at stake here, a lot at risk. And the most important thing that we should talk about right now is that a jury has not even been selected yet. And I know a lot of you are wondering why is that? Why has a jury not been selected yet? It's been the whole week. They're still doing jury selection today. So to help me talk a little bit more about that, I'm here with jury consultant Alan Tuerkheimer. Alan, question for you. This jury selection's going on for quite some time, including today. What's happening here?
Right. Well, some of it might be the judge and the pace that the judge exacts on the process, but it more likely has to do with the questioning. And in a case like this, each side gets to ask the jurors many questions about their suitability to serve. And so they're going to delve into their attitudes about what things that relate to what took place here. They're going to talk about some of their experiences, who's in the military. What do you guys think about guns? What do you think about neighbors who've had disputes? There are all kinds of issues that each side is going to want to talk about to try to figure out whether or not a juror is going to tend to be in favor of them or against them starting out. Plus, a high-profile aspect of the case, or at least the coverage that is generated, some jurors maybe formed an opinion about the case. And so the judge wants to make sure that as this process unfolds, they want to make sure that the jury that gets seated doesn't have any kind of preconceived notions about the guilt or innocence of the defendant, Mr. Woodward. So it can take a long time, and you're right, a lot of people say, what takes so long here? But prospective jurors have to have time to speak and give their perspective, and then it goes back to the parties and the judge, and ultimately everybody has to decide whether or not the people that are seated are going to be fair and impartial. And so that's why it can consist of a lot of back and forth and take a while to ultimately seat a jury.
And it's that, I have to imagine as well, that death penalty, right? That issue as well is really coming up here. I mean, how much do you want to be a fly in the wall in that jury selection process and try to understand what's happening, Alan? I mean, I have to imagine that the death penalty is a really big issue here as well.
Absolutely. So it's one of those issues that people tend to have strong feelings about. And so everybody who's ultimately seated on the jury has to at least be able to consider the death penalty. So if you have one prospective juror that starts talking about how he or she defends the death penalty, they're not going to serve. So you cut through those. But then for everybody else, there are many varying degrees. People might say, yeah, I could consider it. Certain circumstances, I might consider it. And on the other extreme, you have people who are, death penalty, it's a great deterrent for other crimes, other people seeing it, it sends a statement. All these reasons somebody might be very adamantly in favor of that. You have this whole gulf in between those two extreme positions, and that's what the lawyers are going to talk about and hear the jurors talk about what their feelings are with that penalty. Because let's face it, most juries, when they're seated, yes, a lot of times they have to decide whether or not somebody's going to be incarcerated. There's other penalties that you go through the list of least severe, most harsh, but this is the ultimate penalty. So taking someone's life, yes, it's a serious charge and there's a serious consequence.
Yeah, Alan, it's interesting because we've covered cases here on the Law and Crime Network, some out of Florida, where there's been really heinous crimes. I mean, we covered a quadruple homicide. We covered the killing of a young mother and her 2 children. And you would imagine that a jury who was selected for a death penalty case in such horrific circumstances, they would have voted in favor of the death penalty. I mean, I imagine that's a question. Can you vote for the death penalty? And I'm sure they say under the right circumstances, yes. And here, in those cases, the death penalty could not be found because you need that unanimous jury verdict. So again, for our viewers, if you can explain it, jurors are human beings, right? No matter how much they say that they can do it, they listen to all the facts, and no matter how heinous the crime can be, that doesn't necessarily mean someone will be sentenced to death, correct?
Correct. It's hard to get jurors to be unanimous on virtually anything, let alone sentencing someone to death or recommending the death penalty. So yes, you can have people that come in and they're in favor of it. Maybe they know about the Tsarnaev brothers or the Oklahoma City bombing. In their minds, they think, yeah, death penalty for someone like that, or Holmes in Colorado, or even some of the Florida cases that you were mentioning, where they're just really horrific facts. But they're gonna, if they don't hear from Mr. Woodward, if he doesn't take the stand either way, he's gonna be in the courtroom. They're gonna watch him. They're gonna be around him, and it's hard to get a unanimous death penalty verdict rendered. All it takes for the defense is to get one juror to say, you know what, not that I have any doubt about that he did it. It's clear that he did it, but with his state of mind, or maybe thought he was protecting his family, whatever it is, I just cannot sentence him to death. So it is difficult, and it's something that jurors struggle with. Even after they serve, after they either render a death penalty or don't, it sticks with them for a long time. So they take it very, very seriously.
And this case is unique in the sense that you see a self-defense kind of argument, a justifiable homicide kind of argument. And you talked a little bit about it when a jury is being selected in this case to talk about the disputes that they've had with their neighbors. But in these kinds of self-defense cases, what kind of questions, and I have to imagine that that is one of the reasons why this is a prolonged jury selection process. Walk us through some of those questions and the difficulty in self-defense justifiable homicide kind of cases where you're selecting a jury.
Sure. The lawyers are going to want to know who's been badgered by a neighbor, who's been badgered by anybody, who's had a dispute with a neighbor, who's had to stick up for to defend their rights when you felt they were being threatened. So they're going to ask the jurors about experiences that they've had with that. But also, if not everybody has that experience, they might have an attitude about it. So they might say, who here thinks that if you feel like you're somebody's being threatened or somebody's threatening your family, you have every right to take the law into your own hands and deal with it. And that can generate a lot of discussion, and people might raise their hands and different perspectives might come up. So it takes a while, as we talked about earlier, to flush through these attitudes. But the discussion is probably going to focus on this notion of doing something what you believe is right, even though on paper, or I guess literally, it's against the law. Because you will have some people who think, hey, I would have done the same thing if I honestly felt that my family was being threatened.
Yeah, and here in this one, it's a little bit different from what we know so far. Trial hasn't started yet, but from what we know so far, it seems like this was months of provocation, and he was built up for a long time. And again, at the end of the day, how much that'll actually play might not matter, because it really matters what happened at that exact moment, right? You know, we talk about what happened at that exact moment. It's not so much what happened weeks ago or months ago, what happened at that exact moment. That's what we talk about when we talk about provocation. But what's interesting in this case, Alan, is the prosecution lost on 2 grounds. They tried to limit the jury to hear this justifiable force argument. The judge denied that they're going to hear it. But the other thing, and you mentioned it a little bit before, the prosecutors tried to ask the judge to limit a reference to PTSD. We talked about that Mr. Woodward may suffer that, and the judge denied that. So they're going to hear about this PTSD. And how does a jury usually interpret that kind of the PTSD of war veterans? What are some of the dangers there of juries hearing this information? What are some of the benefits for it for the defense? Can you walk us through that a little bit?
Yes, it does humanize somebody and who has PTSD, and what's going to happen is you'll probably have some jurors that say, oh, you know, my uncle had some PTSD, or I know somebody who had PTSD, and this is why they had it. And so in a way, it humanizes William Woodward to some jurors who have that experience, who they know about it. And so it's not this, for people who know nothing about it, who haven't thought much about PTSD, then that's the type of person who's going to say, you know what, I don't really buy this fully. It doesn't really resonate with me. Can anybody just say that they have post-traumatic stress? So it is interesting, and it's a dynamic that is going to be talked about probably in the deliberations, but certainly when selecting a jury, the lawyers want to know who, if anybody's ever suffered from PTSD, or more likely, who knows somebody or who has a relative or a close friend who suffered from it, because that really is going to influence how they perceive the evidence as it unfolds in the case, and it's certainly going to affect their perceptions of the defendant himself.
Yeah, Alan, they are still trying to select that jury today. They're still trying to select it. We hopefully they have it selected by the end of the day so that we can cover it live beginning next week. We'll see. There's a lot of factors going into that selection of the jury, as we talked about: PTSD, death penalty, dispute with neighbors, justifiable homicide. A lot for them to work through. But Alan, I want you to stand by. I would like your final thoughts about the Jason King case. But before we do that, I want to play our viewers just a short clip of some of the testimony from yesterday. Again, in the Jason Riley King case out of San Diego, California, that Marine who was accused of driving drunk and killing, which resulted in a head-on collision as he drove on the wrong side of the road, killing 2 people and injuring 3 others. Here's a short clip, and when we come back, Alan and I are going to have some final thoughts about the jury selection in the Jason Riley King case. Take a look at this.
Dr. Mann, where do you currently work?
I work in the Ventura County.
What do you do in Ventura County?
I'm the Assistant Chief Medical Examiner.
How long have you had that position?
Only 3 months.
Where did you work before Ventura County?
I worked for San Diego County for 10 years and 3 months.
What was your role with San Diego County?
I was a Deputy Medical Examiner.
What sort of training and experience do you have to have in order to become a Deputy Medical Examiner?
Well, it starts with college. I have a physiology degree from UCLA. I went to medical school at UCLA. I then did training in clinical and anatomic pathology at UCLA Medical Center. I then followed that up by a subspecialty or fellowship training in forensic pathology in the New Mexico Office of the Medical Investigator. And since then, after that, I worked in San Diego. But I'm licensed to practice medicine, and I am certified by the American Board of Pathology to practice anatomic, clinical, and forensic pathology.
In your time with San Diego County as a Deputy Medical Examiner, how many bodies did you autopsy?
I autopsied approximately 2,700 while in San Diego.
And is there a certain protocol or a certain time when the medical examiner's office is required to do an autopsy?
It's up to the discretion of the on-duty pathologist. We autopsy approximately 2/3 of the people who fall under our jurisdiction for a postmortem examination. But the majority of the unnatural deaths would get an autopsy. And by that I mean both an external and an internal examination. The other third would get only a external examination and review of medical records.
When you say unnatural death, what do you mean?
Any death that is accidental, suicidal, homicidal, or undetermined.
So if something is undetermined, is that considered the same as unnatural?
No. Undetermined means that the manner of death, meaning natural, suicide, accident, or homicide, could not be determined due to circumstances or condition of the body, or one manner of death was just as likely as another.
And when you're creating a classification for or a manner of death, is that are only the 4 available, or is there another form of death that you would also classify, as as far as in doing your examination?
No, it's one of those four that I mentioned or undetermined. So there are 5 manners of death that we have.
Now, when you're doing an autopsy, is there a certain process that you follow?
Yes. Well, every doctor's a little different. Meaning, I guess there are different styles and order of things, but typically it begins with a review of the circumstances and whatever reports we have available, followed by an external examination that includes documentation of external injuries, what the body looks like, height, weight, those sorts of things. And then that's followed by an internal examination, which is documentation of any other injuries and evidence of natural disease, organ by organ. That's followed with a toxicology report and ultimately in a final autopsy report.
And when you're doing the autopsy, are you taking notes somehow while you're doing the autopsy?
Yes.
Now, and at the end, once you've completed your autopsy, is it fair to say that you then create a report?
Yes.
Dr. Mena, I'm showing you 2 reports, numbered 87 and 88. Do you recognize those 2 reports?
Yes, I do.
How do you recognize them?
They're standard County of San Diego issued autopsy reports, and I prepared both of these.
When you prepared those reports, would it be fair to say that you prepared them in the normal course of your business?
Yes.
And when you prepared those reports,
That's Dr. Mena, the Assistant Chief Medical Examiner from the Jason Riley King case out of San Diego, California. We're showing you replays of that clip, the whole testimony from yesterday and from this whole case, because we are in a break in that case until Tuesday after the holiday weekend when it should pick back up. I'm here right now with jury consultant, Alan Tuerkheimer. And Alan, I had some final questions for you for this case. I want to talk to you now real quickly about what might be resonating with the jury. And do you think the idea that, okay, this Marine went to stand down driving presentations where they were police officers instructed the Marines about the dangers of drunk driving, and he went to it a few days before the collision. Is that really resonating for the jury, or they're saying, you know what, this is overkill? Everybody knows the dangers of drunk driving.
I think that there's a combined effect going on with his knowledge before this. I think that certainly hindsight plays a role, but I do think that coupled with what happened on the night of the accident. Now, I do think that you're probably right. If they overplayed this notion that, 8 days ago, the military sponsored a Don't Drink and Drive campaign, I don't know how much that's going to get them. I think what's really going to resonate is this notion that he didn't listen to anybody on the night of the accident. He was at this motel and friends tried to stop him. Bartender intervened or tried to intervene, and he was just hell-bent on getting into his car. And I think that's going to be troublesome to jurors who are trying to pick together what really happened. So I think that's probably the perspective that the prosecution wants to hammer home, that there were all these warning signs and opportunities for this not to have happened, and look what happened. He went ahead, and there were so many ways this could have been avoided, but it wasn't avoided, and the fault is Jason King.
And that's what the prosecution is really stressing there. They're saying that he knew what he was doing. He knew what he was doing by getting behind the wheel, and that is why he should be charged with second-degree murder, showing that he had a depraved indifference to human life. But that's what makes this case really unique, that case of, is this manslaughter or is this murder? And I love watching defense attorneys come up with very unique arguments. And I see it from the prosecution too, but the way that they're structuring it here is they're saying that, the defense, is saying that when he got behind the wheel of that car, did he know that he could face murder charges? No, he never knew that. The stand-down presentation never told him that he could face murder charges. I thought that was interesting. Do you think the jurors are thinking about that as well?
Yes, I think that's a very good argument. The defense attorney in you, or former defense attorney in you, shows through and has appreciation for that. But I can get behind that too. That is a good argument, because it's not like the defense is getting up here and saying, let's let him go, and he won't do it again. He's sorry. He's contrite. They're basically saying, look, put yourself in his shoes without saying it. He didn't know any of these things. He didn't know that this was a possibility. Now, the counter argument or counter thought to that is, look, he was so persistent with his actions that night that even if he did think that, even if one of his friends or a bartender or someone at the motel said, look, you could face murder charges before you get in the car, so don't do it, I don't think that would have changed things. So that might be discussed in the jury room. But I do think that, yes, this is an absolutely, it's an effective way for the defense to go about trying to humanize it a little and saying, hey, look, it's unfair. If you look at the charge, you look at the law for second-degree murder and what knowledge has to take place, he didn't have it. He did not think that he could be standing here in front of you being charged with second-degree murder. So I do think it's
knowledge of what the law is not usually an element of a crime. It's not usually a factor that goes into it. But it is a good argument. It's an interesting argument to follow. I wonder, when I first heard this case, and I think when most people first heard this case, they were surprised to hear those murder charges. You think DUI, you think manslaughter, you don't think murder. And I think this might be a unique case in that fashion. I wonder how much that is for jurors, too, looking at this and saying, wow, I never really thought of this as murder before, and maybe this really isn't murder. Maybe this is more manslaughter. I would like just your final thoughts as what the jury may or may not be taking away from this in terms of that murder-manslaughter difference and dichotomy.
Sure, and I think you're right. I think when the jury was seated and first heard about this, they have a conception of murder, and they think of what they see on TV, where somebody has a plan and they have a deliberative plan to take somebody else's life. Well, this is certainly different, so there's an expectation violation from what they had thought about going in. But with time, and he's been charged with murder, and the more they hear the facts of the case, and the more they hear about second-degree murder, the more in a way it legitimizes this notion that, yes, he didn't set out, he didn't get a gun and go to somebody's house and purposely pull the trigger to kill somebody, but it does sort of desensitize them to the notion that murder has to be something completely different.
Right.
So it's a possibility. I think that they're going to struggle with it, and they're going to look at the law, and they're going to parse through the words, and they're going to have to decide what they should do. And some jurors are going to want to say, hey, this is our opportunity to really put a stop to this. Drunk driving is the worst possible thing. We can say second-degree murder, while others are going to say, look, let's be a little more limited in what we're doing here. He's young, and he's going to serve his time anyway. But I think murder is a little heavy-handed.
Yeah, it's an interesting case to follow. Alan, thank you so much for your time, your insight into this case, into the jury being selected in both the Jason Riley King case as well as the William Woodward case. We appreciate you coming on.
Nice to be here, Jesse. Good to see you.
Good seeing you.